I could have your attention, please, I'll call this meeting to order. This is our March meeting of the Wilson County Board of Zoning Appeals. Do we have anyone this morning who has a case on the agenda that would like to withdraw? Or maybe defer to a later date? If we don't,
Mr. Chairman, we did have one case withdrawal after the agenda was published. It's case 4162, Robert Ham at 5633 Scenic Ridge Drive.
okay, so 4162, 4162 Eric Radley?
Yes.
I thought you said someone else,
I
huh?
have Robert Ham.
I've got Robert.
I've got Eric Radley at 4162.
Got a mistake right here. Two cases are the same. Depends on the staff comments,
that's
it's
fine.
got a different name.
Okay, so on the staff comments, I've got case 4158 twice. So that should be 59 on the staff comments. That second case should be 4159. And then on 4162, that should read, if I can get over to my page here. That should read Eric Radley, correct?
Yes, I think so. Christopher, do you know where Robert Ham came from? Okay.
Okay. All right, so we'll correct those. All right. So case 4162 is deferred, or no, it's withdrawn. Yes, what'd you have to say?
I'm gonna defer.
And what is your case number?
4163.
4163. Hold on. So this would be Jason Lewis and Jason Nichols.
Correct.
Wish to defer to another meeting.
Later meeting? Yes, sir.
And do you have a date, or you just want us to defer till you request to get back on?
We'll request to get back on.
Okay, that's fine. All right, anyone else?
After,
Until,
what's our typical policy? After 60 days, they've got to come back and pay again?
Till April,
Yeah.
April, May meeting.
Okay, so
Okay.
you're clear on that?
Yeah.
Okay,
Yep.
that's fine. Anyone else here who wish to withdraw or defer?
A deferral, you'll have to take action on.
I will.
Okay.
Okay. If there's no one else here that wishes to defer, I move that we defer case 4163 until the applicant requests to get back on the April or May agenda.
Second.
Have a second discussion? If none, all in favor vote aye. Aye. Opposed vote no. And the ayes have it. Okay. That done. All right. Just so everyone's aware, we have a court recorder here with us this morning that's taking a record of our proceedings. The court recorder is provided at the expense of Wilson County. If you wish a transcript of a particular case, then that would be at your expense, and you would need to see the court recorder at the conclusion of today's meeting. Just a reminder to everyone, if I could please, to silence your cell phones. If you're here today to represent a case or to speak in favor or in opposition to a case, please come to the podium when we call the case. We'll let the applicant have an opportunity to speak first, and then after the applicant has the opportunity to speak, we'll let anyone else who wishes to address the board have the opportunity to do so. In regard to each case, the staff has made recommendations to the board, and the board will consider those recommendations when we're rendering our decisions. Another reminder, the proceedings today are being taped for replay on Wilson County Television if you're interested in viewing the meeting at a later date. Also, the state has mandated that before each public meeting, we are to have a short public comment period. Has anyone, Tom or Karen, signed up for the general comment period?
Not to my knowledge.
not that
Okay.
I'm
This is not in regard to any particular case. This is a state mandated comment period that has to occur before each public meeting. So you'll all be given the opportunity to speak to a case later on as it's called. All right, if you do plan to make a statement in front of the board this morning, you'll need to be sworn in. So at this time, if you do intend to speak, please raise your right hand and take the oath. You hereby swear or solemnly swear that the testimony you're about to give in front of this board to be the truth, the whole truth, and nothing but the truth, so help you God.
I do.
Thank you. All right. To the members of the board, you were sent the minutes of the February meeting several days ago. You've had an opportunity to review those. Do I have any corrections to the minutes from the month of February? If not, do I hear a motion we approve February's minutes?
Motion to approve.
Have a motion to approve the minutes from February. To have a second?
Second.
Have a motion and second. Any discussion? If not, all in favor vote aye.
Aye.
Opposition vote no. The ayes have it. Okay. Moving into the regular agenda. Case number 4158, Melinda Forbes is requesting to renew an approval for a short-term rental. The board approved the short-term rental on March the 4th, 2021 for a period of 3 years. The property is located at 445 Old Statesville Road, parcel 67.05 on Wilson County Tax Map 128. The property consists of 5 acres and is zoned A1 agricultural. We get staff recommendations on 4158.
Mr. Chairman, the applicant is requesting to renew an approval for a short-term rental. The short-term rental was originally approved with the following conditions. The maximum number of occupants is 8. The business plan is part of the approval. Both the wedding venue and the short-term rental that are on the property can't be used at the same time, and no outside activities after 10 p.m. The business plan staff received with the applicant's application upholds the conditions listed above. The use and amenities of the property have not changed, nor have there been any public complaints of note about the property. Staff can recommend approval of the request. There's no language in the zoning ordinance or zoning regulations granting staff permission to renew short-term rental approvals. However, there is a provision that requires that short-term rental uses or bed and breakfasts have to be approved for a finite period of time. The board may consider that request. Staff will point out that in renewal cases such as this, if the request is approved, the board typically grants an extended renewal period.
We done after 3 years? 5?
We haven't had a whole lot that have made it that far, but I think so, 5 years.
Okay. All right. Who's here to represent 4158 Forbes? Name and address for the record, please.
Melinda Forbes. My address is 747 Shot Springs Road, Watertown.
Okay. Anything you'd like to tell the board?
Not in particular. There's no changes really made. My management company, Evolve, has been very proactive in cases where there was people who wanted more than 8 people. We've had a few just minor damage claims. They've been excellent. But overall, everything's worked out real well. As far as the event portion, we've had a couple of Airbnbs who, thankfully, they let us know that they wanted to rent the Airbnb and then have an event at the same time, and that has not happened, and so we've not had that occur, and it's not been an issue.
Okay. Does the board have any questions for the applicant?
Not that it's an issue, but maybe just out of curiosity, has the original request is like 7.5 acres, and now it's 5 acres. Is that just?
There's 2 different addresses.
Okay. And I don't mean that, I mean, that's not a big issue. I just know
Yes.
there's a difference in it.
The house and 5 acres, I guess it is address of 445 Old Statesville Road, and then a separate driveway that actually goes back to what we call the pavilion and the wedding site and all that is 433 Old Statesville Road. So there's actually 2 physical
Okay.
addresses.
But the land itself hasn't been split up?
No.
Or
And
changed?
And the short-term rental occurs at 4:45, whereas the
Yes.
events occur at
Okay,
Yes, that's correct.
I got you. Thank you.
Any other questions by the board? Okay, does anyone else here wish to address 4158 Forbes? Okay, not, I'll close the public comment on 4158, thank you. Turning to the board, in regard to case 4158 Forbes, do I have a motion or discussion?
Mr. Chairman, I will move that we approve this based on staff recommendations and the history of no complaints for 5 years.
Have a motion to reapprove the venue
That's correct.
for a period of 5 years. Do I have a second?
Second.
Have a motion and a second. Any discussion?
Is that Blades or Crockett made the second?
Keith, you want credit?
It doesn't matter.
Okay.
Put down Blades second.
If there's no discussion, all in favor vote aye. Aye. Opposition vote no, and the ayes have it. Our next case is case 4159, Matt Irving, requesting a temporary restroom trailer. The property is located at 3436 Couchville Industrial Boulevard, Lot 4, Couchville Business Park, parcel 2.19 on Wilson County Tax Map 137. The property consists of 21.35 acres and is on C3 Highway Commercial. We get staff recommendations now on 4159.
Mr. Chairman, this is a truck parking facility that it was approved by master plan, plan unit development, across from Love's. If you'll look back, or I guess I can do it back here too for y'all. If it, this is the Love's and the Love's truck parking, and this is the truck parking facility that was approved by, I think it's C3 Highway Commercial with a plan unit development overlay. At that time, when they went through the plan unit development overlay process, they had a master plan that was approved as a matter of zoning with the county commission. And at that time, they stated that they would not need restrooms, that they would be making use of, their occupants would be making use of Love's facilities, being across the street from them. So with that, I'll proceed with my comments. Applicant is requesting a temporary restroom trailer. The restroom trailer will be used to gauge customer traffic at the facility. Based on the documents submitted to the staff, the trailer will be 21 feet long and consist of 4 individual bathrooms and will not require any connection to public water or sewer, as it has independent holding tanks. The applicant stated in discussions with staff that there would not be restrooms on site and that a deal had been made with Love's to utilize their restrooms, therefore they would not be utilizing the sewer tap on their site. That speaks to what I was talking about during their master plan approval process by the county commission. This was approved as part of the C3 PUD, or plan unit development, based on testimony by the applicant that there would be no water usage on the property on April 16, 2021. Staff would also point out that the proposed above-ground septic tank is not a certifiable septic system by the state of Tennessee, at least within Wilson County, and if a restroom was to be placed on site permanently, I think is what that's supposed to say, they would be required to tie into public sewer, which is available at a price and process that they would have to go through for approval. Given the language in zoning ordinance, staff cannot recommend approval. This property does have the ability to connect to the sewer infrastructure that's available in the South Wilson planned growth area. If the board were to approve this, then staff feels there would be a need to have some sort of time constraint placed on the site with regard to temporary restroom usage, so it doesn't set a precedent for temporary restroom facilities in commercial districts. We have allowed a couple in our past for somebody that was moving into a site that already had bathrooms that they were connecting up, but they were still working on the sewer connection to be finalized in this vicinity, but that was more or less during construction. This construction is complete. The one thing I will say, based on the submittal that the applicant made, is it sounds as though they're wanting to almost to use it to gauge how much traffic they have. I don't know if that means that they would ultimately possibly decide to establish permanent restroom facilities or not, but that may be what they're trying to do, is determine whether or not there's a real need for it.
The access to this site is from the Lowe's parking area?
No, this is Couchville Industrial Boulevard. And so Love's is over here, and there's access to the truck parking at Love's in the back here. There's also access to the gas pumps in the front of the store up here. And this is across the street from the truck parking. Their access is this way. Toward, okay, so that's their exit. This is their access down here.
I got it. I see them now. I didn't see them before. Okay. Who should represent 4159, Matt Irving? Give us your name and address, please.
Matt Irving, 4121 Lawrence Drive, Little Rock, Arkansas.
And what would you like to tell the board, sir?
So I would say he's exactly right. We do not have an intent to build permanent facilities. So the original, what the plan was originally has not changed. What we would like to do with this temporary restroom is raise awareness of the parking lot. We still have the belief that the Love's facility is sufficient and has sufficient facilities. We think it does make a difference for us with customer traffic if there's something that they can use on site. But once we get the awareness of the lot build up in that 3 to 6 month time frame, again, it's temporary. We don't view it as permanent. We believe the drivers can use Love's.
Is this part of Love's? Is this a private development?
It's a private development
So this is a parking lot that you would charge people to park in?
for truck drivers mainly. Yes.
Okay.
Yep.
Gotcha. Okay.
What does Love say of your customers using their facilities, or do they know, or do they have a comment?
So a little bit of my background. So I work for Truck Park Management. Big Rig Parking owns the lot. We just manage it for Big Rig Parking. I know they had conversations up front with Love's, but I wasn't privy to that. I mean, generally, I can speak in general terms of truck stops. They want to sell fuel. That's their main driver. So even if we're bringing drivers to our parking lot and they're buying fuel from them, they're indifferent. Yeah, they welcome the customers. And that's a general comment, not necessarily that Love's.
So what is your definition of temporary?
We'd like 3 to 6 months.
And then what happens?
We'll move it. We'll take it to a different location.
And if I park my truck there and the restroom's gone, what do I do?
Well, again, we believe that the Love's is sufficient, right? So we list that as amenities for the parking lot. And so I do think that the truck drivers will be comfortable with going to Love's. It's just getting them aware that the truck park is there is what our intent is. And when we talk about gauging traffic, we want to understand for some of, we develop and build lots all over the U.S. So we would like to understand, okay, if we put this amenity here, does that increase our customer traffic? We could be wrong. It may not.
If it does increase your customer traffic, would you be back at least requesting sewer access in a permanent facility before the Sewer Access Committee and subsequently the Planning Commission for a site plan approval of the bathroom facility? If your statistics showed that the bathroom was necessary?
Yeah. I don't want to say there's not that possibility, and I don't want to speak directly for Big Rig, but I don't think they have any desire in building any facilities at this lot.
You know, I don't understand. If they're
Yep.
not gonna have a permanent restroom there,
Mhm.
and I hate, well, my experience is if there's not a restroom close by, people will make their own arrangements.
Right.
But if they're not gonna have a restroom facility there, why put one there temporarily and then remove it?
Well, again, it's all about your customers' habits. So once you get the lot established and drivers know that it's there, we think the Love's is sufficient. We think it's close enough in proximity that they'll go there. But we do think this temporary restroom trailer is an amenity that will bring them there the first time. So once they're there the first time, then we think they'll realize that the Love's is sufficient. Does that make sense or answer your question?
No, it doesn't.
Okay.
I dealt with Big Rig Parking
Yeah.
whenever they started this.
Mhm.
And it was, I asked them when they started doing this with the plans and all that stuff, why would you have all this out here and you don't have a restroom out here? What are they gonna do?
Right.
And he said it wasn't needed.
Yeah.
All they wanted to put out there was just the place for
And
the big trucks
I mean,
to park.
at that time,
At that time,
at
you're
that
right.
time, the suggestion we got, or the indications we got from the applicant for rezoning and for site plan approval was that the bathrooms were not necessarily necessary because they would direct people to Love's. Is that
Yeah.
correct?
Which is
I mean,
what we're doing.
I'm not familiar with the trucking industry,
Sure.
but would they not be aware of the parking through word of mouth or advertise? I don't understand how putting a porta john out there is gonna make truckers all of a sudden say, hey, we need to go over and park.
So
I don't follow that.
it is a big deal to truck drivers to have bathrooms on site.
Okay, so then you get them there, and then as soon as they start funding, you're gonna take them away from them.
Well, again, I think, right, yeah, I get what you're saying completely, and I understand it. I think once we get their habits of coming there, and
Where they rest.
we're not trying to trick them,
Right.
but we do believe that the Loves is close enough, the original intent of the application, that they can use the Loves facilities.
We've sort of drifted off into your business plan, and we should.
That's all right.
But I think these are relevant questions. Anyone else have any questions? Yes, sir, go ahead.
Is there anybody that's gonna be on that property permanent?
No.
They have security cameras
I
associated
have
with
a-
the lot.
I have a picture here, I don't know who provided it, looks like there's a person living there with a trailer behind a pickup truck. I don't know who provided this picture.
That's our field review.
Christopher. and,
That's probably somebody just rented space for the night.
Yeah, we have monthly and nightly parking.
So it'll be
Monthly.
more than 18-wheelers parking.
There could be, absolutely. It's directed towards 18-wheelers, but, you know, will we reserve a spot to a truck and a camper? Absolutely, if they want to park it out there month by month.
Any other questions? If not, does anyone else wish to address 4159 Irving? If not, I'll close the public comment.
Thank
Thank
you.
you, sir. Turn to the board for discussion or motion.
I'll make a motion to deny the
Have a
request.
motion to deny case 4159. Do I have a second? I'll second. Any discussion? Any discussion on the motion to deny? If not, all in favor vote aye. Aye. Opposition vote no. The ayes have it. Our next case is case 4160. Tony Eckler is requesting to waive the commercial sewer and paving requirements placed on him by the Board of Zoning Appeals. The board approved the deer processing business on March 4th, 2021. The property is located at 2771 Hunters Point Pike, left of which property, Group B, Parcel 1, on Wilson County Tax Map 45E. The property consists of .92 acres and is zoned A1 agricultural. We get staff recommendations now on 4160.
Mr. Chairman, the applicant is requesting to waive the commercial sewer and paving requirements placed on him by the Board of Zoning Appeals with their previous approval of this use. The applicant has also modified his plot plan from the prior Board of Zoning Appeals approval. The applicant previously proposed the addition of a new structure behind the existing garage to house the proposed deer and game processing use. The applicant now wishes to forgo additional structures and make use of the existing garage, which had previously been dedicated on the record for personal storage needs in his previous approval from you all. He now wishes to use that existing garage instead of using it for personal storage. He wishes to forgo building a new facility for deer processing and use the existing garage as his deer processing facility. Does that make sense? Okay. The zoning ordinance states, within any commercial or industrial zone district, the following will be required. Prior to any commercial or industrial use of property, a public sewer system as defined by this zoning ordinance must be in place for the provision of sewage disposal. When I have the ordinance reference there, section 3.41, commercial or industrial use of property. We also have commercial parking areas requirements whereby they're required to be paved with a dustless surface. These ordinance requirements are being referenced specifically because the board required that commercial development requirements be met with their previous approval of the deer processing facility on this property. However, the board has considered these types of requests in the past if the applicant is able to prove to the board's satisfaction that the existing septic system is adequate to support these uses. The applicant is seeking to use the bathrooms in the residence on site for himself and his one employee during processing season, and states that it should be more than adequate to support the additional person. The ordinance also states all areas devoted to off-street parking and access drives as required under this section shall be of sealed surface construction of plant mix asphalt or concrete construction. The applicant has stated to staff that there's no longer going to be an addition on the site and is going to utilize existing structures on the property. The applicant is, however, on notice that if he does choose to expand his facility with new structures, that the building material and additional landscaping requirements would be required to be met unless variance for such is further granted by this board. Given the language in the zoning ordinance and the previous Board of Zoning Appeals approval conditions, staff does not feel they can recommend approval.
Okay. Who's here to represent 4160 Eckler? Yes, sir.
This is A1 zoned, so the commercial requirements aspect came specifically from a condition that y'all placed on it.
Okay. Name and address, please.
Tony Eckler, 2771 Hunters Point Pike.
And what would you like to tell the board?
So, 3 years ago, I got approved. The holding tank, after y'all approved me, I was trying to move forward, and we had a little misunderstanding with TDEC. The gentleman that was in charge of a pump and a haul permit, I was trying to get approved from him, and I thought I had to get this pump and haul permit. Well, I just went and met with him a few weeks ago, and the misunderstanding was I got frustrated 3 years ago and decided not to do it because on that pump and haul permit, he told me it was going to take 3 months to process the application, and it seemed like he was trying to discourage me. Anyway, I couldn't wait 3 months to get the permit. I wasn't going to be able to get it done on time, so I kind of got frustrated and decided not to do it. Well, I went and met with him a few weeks ago and found out what the problem was and what the misunderstanding was. Is he thought the holding tank, that there was going to be a bathroom in the facility, and so the holding tank was going to be catching that. So the holding tank that I'm having on there is only going to be catching water, just cleaning water, and that's it. So he said that I didn't have to get a pump and haul permit, that he was good, it was no big deal, since it was just catching water. So that was the thing that kind of deterred me and kept me from doing it 3 years ago. So I've gotten all that taken care of. I actually talked to the city this morning. So when I met with Wade Murphy, is his name at TDEC, when I met with him a few weeks ago, he sent me to the Wilson County Wastewater Authority because he thought that they would be the ones that would help me with the holding tank and for somebody to pump it. So I went and met with the guy there, and as it turns out, I'm in the urban growth for the city, so he told me I need to get in contact with the city. So I got in contact with the city. I actually talked to Regina Santana this morning, and she said it wasn't going to be a problem. I sent her an email, and she just has to, she said as long as the state was good with it, that they're good with it. So in other words, the holding tank's just going to be catching the cleaning water, and it'll just be pumped out, by a septic tank truck. As for the gravel, the state, the guy from the Department of Agriculture, I emailed him and told him that I was coming to this zoning and appeals meeting, and I told him that one of the things was, I had a gravel parking lot and I had to get a variance in it, and he emailed me back and told me some things he wanted me to do to get back with him, and he didn't say anything about the gravel, so I don't think the state's going to have a problem with that either. Which everything's going to be closed off. If you see what I gave you, it's the facility inside where we're going to process the deer is completely shut off, and I mean my parking lot doesn't. I've never seen any dust in my parking lot anyway, but regardless, if I needed to treat it with something, I would, but I really don't think it's necessary.
If I recall, the concern of the board was that there was going to be a number of people coming and going here during deer season, and they wanted to see some level of commercial arrangements, like where these people are going to park, where they're going to unload, how you're going to keep from stacking up on the highway if you have 20 people show up one morning.
Yeah, I mean, I think I have.
The lot's less than an acre, and it also has your house on it, right?
Right, correct. But, you know, the driveway pulling in, there's sufficient room in the big area in between the shops there to turn around. And as for the area coming in, I actually widened the entrance a little bit, you can see already, but I'm actually gonna bring that out another 6 foot, add to that culvert and widen it to where 2 vehicles can come in and out of that area. You know, and then the rest of it, there's plenty of room to turn around there. So the stretch pulling in there, I'm gonna widen that wide enough where 2 vehicles can go in and out. And, you know, and this is just a part-time business for me and my lead guy that works for me. I've had a sealing and staining business I've been doing it for 17 years, but I've had Mid-South Seal and Stain for 9 years now, and the same guy's been with me, and we shut down in November.
But that's all fine for you, but these type of things run with the land. So if we were to approve this A1 piece, this is A1, yes, A1 piece of property would then be approved for a commercial use without any commercial improvements. And if you decide to sell it in 2 years, then that's what you would have to sell is basically an A1 lot that's been turned into a commercial by this board without any stipulations.
Well, we did have stipulations. I've got them right here. I met with Tom after I got approved 3 years ago, and here are the 3 stipulations that he told me I had to go by. He said I didn't have to go by not all the commercial standards, just these 3. And it was doing the landscaping, and if I was building a new building, the front of it couldn't be metal, so it had to be, I was gonna do hardy board. And the 3rd one was to put a fence in front of the dumpster. And so those are the 3 stipulations that he told me I had to go by. When we had the meeting, he said I wouldn't have to go by all commercial standards, but I would have to do some, and those are the 3 that he
Let
gave me.
clarify that for us, Tom, if you would. Why did he not have to meet all the commercial standards?
Well, when he came back and visited with us approximately a month ago, we went back and listened to the transcript, and it would appear, because there was no indication of exception from any of them, that he would. That's why he's here.
And 3 years ago, I mean, half of the board, I mean, I didn't even think I should have to go by commercial standards at all. I thought it should just be a household.
I remember this case
you know.
pretty good, because I felt like this was possibly something that could fall under a home occupation. I don't know if that's worth bringing up here now, if it's even before the board, but I remember at the time that we approved this, and I don't think I voted to approve it, I felt like it was under a home occupation, but is that even something that needs to be discussed now?
I think
The use you've already made a determination on. It's just a matter of you've made that determination with conditions.
Well, Mr. Chairman, it said like if he sells a property, then it's got a commercial use that goes with it. If we allow home occupation, you sell the property.
If someone else bought this property and wanted to do a deer processing facility and wanted to meet the commercial standards that you required of them, they could do that.
But what about if they wanted to not do deer processing, but they wanted to sell
They would have
retail
to-
goods? I mean,
they
is
would have to- they'd have
it
to-
open
they'd
the
have to-
door to all commercial
No,
products?
they'd have to come back. and
what
get
about
retail.
beef process?
That may be considered similar.
Yeah.
So, I mean, that was a question I was gonna ask too, is, you know, at this point, 3 years later, coming back as if, you know, we could back up and maybe try to make it a home occupancy.
I think the concern, if I recall, was the volume of folks that might, if you were doing a home occupation and the UPS truck comes in once or twice a week, picks up a box of widgets you've built and delivers some raw material, that's one thing. But when you have a facility like this that might have a number of people coming and going over the season, you might have, 10 or 20 people one Saturday morning show up for processing, then that brings on the question, is that a home occupation? Because it far exceeds what we normally would consider a home occupation.
Yeah, and I mean, for the deer season, it's, the month of November is the only month that it could get, busy. But I can only do so much there. So, I mean, I'm doing this for part-time. I'm only gonna do as much as I wanna do. And, I mean, it's something for me and the guy that works for me to give us something to do for a couple more months after my business shuts down. So, but the reason I say the month of November, so, deer season has a bow season that opens up at the end of September, and it's pretty much the month of October. And that'll be slow. During bow season, you don't get a lot. But then the 1st of November, when muzzleloader season opens up, and then rifle, those are the 3 or 4 weeks. So there's only really 3 or 4 weeks, 1 month out of the year that it will be busy. And I mean, I think I have, with me widening the in and out, making it for 2 vehicles to go in and out, I think I've got plenty of room to do what I need to do.
And obviously, I'm assuming you don't schedule drop-offs, because obviously people harvest a deer, they bring it, but you will schedule pickups as far as when somebody comes to pick their meat up. You
Yes.
can schedule it during maybe a
Yes,
slow time of
absolutely.
the day. Or,
So, yeah, so the pickup, we can, do that, yes, absolutely. So, no, I can't control when they're coming in, but I can control when they do the pickup, yes, sir.
Any other questions for the applicant? If not, does anyone else here wish to address 4160 Eckler? Not, if you don't have anything else to say, Mr. Eckler, we'll close this public comment period.
No.
Thank you. Turning to the board for a motion or further discussion.
Tom, you're requesting landscaping.
Only if he adds additional buildings would he get hit with those requirements.
Okay, so, but he's not.
The landscape and build material requirements would come if he
Okay, but
made any
according
additional improvements.
To today's testimony, he's not adding additional buildings.
No, he's proposed not to add the additional buildings,
So you're requesting paving.
paving and, sewer requirement.
Now, if a person goes out and say there's a house on the side of the road and they get it approved for commercial use and we've made the same stipulation, that's all the commercial, an existing building, that's all the commercial requirements there are is landscaping and paving and sewer?
Landscaping, paving, sewer, and paving, landscaping, sewer, building material and paving.
Well, it's existing.
The existing, if they're not making any improvements, like they're not
What about stormwater?
increasing their parking lots, they're not increasing stormwater, they're not making significant grading or anything, then yes, they can go in that building and operate commercially by right in that zone district.
So there's no stormwater requirement?
No, for instance, a good example, something that might do that in a house would be a real estate office, or we've got several of those.
So there's gonna be those three, sewer, parking, and landscaping?
Sewer, parking, landscaping, building material,
But only building material if they improve.
if they make improvements.
Gotcha.
And since I'm not doing a new building, does that mean I don't have to do the landscaping thing now?
Correct.
Okay.
But let me ask a question here. If Mr. Eckler decides to start processing beef there, does he need to come back before the board? Or,
I will tell you my opinion on it. I would probably interpret that they're processing meat and be done
This is
with
sort
it.
of important, so I don't wanna let's talk in
Okay.
definites, cause this could get to be serious.
Okay. Well,
Let's
if-
say, for instance, this were approved,
If you
and
tell
he
me,
wants-
if you instruct me to, if he changes what he's processing there, I can bring him back to the board.
Yeah, I,
Left to my own devices, I would likely interpret that that's the same use.
yeah, well, that's what I'm getting at, is
Yeah.
if you get approval for a deer processing plant or facility,
Mhm.
and then 2 years from now, you're processing beef, at a considerable clip, and you're gonna consider that to be the same or similar, then we've just turned that loose, and I'm trying to think what else we're turning loose.
Well,
I mean, I think a butcher shop effectively, if you wanna just use a general term, is what you're turning loose. Any other use of the property that's commercial in nature would likely need to come before the, county commission for
But the only
rezoning.
thing between a slaughterhouse and this is the particular animals are being killed off-site.
Yeah, but his original approval said he would not be slaughtered on site.
Right, but what I'm saying, the only difference
Right.
between, that is where the animal is put to death.
and I'm not doing beef. This is just a part-time deer, 100%, I'm only doing deer. I'd have to set up the operation differently if I was ever gonna do beef. The ceiling would have to be higher, there's lots of different stuff, and I'm not fluent with that. I only wanna do deer, so if we have to make some kind of stipulation that says I can, only do
Well,
deer
and the
around
fact
them.
that deer is gonna be very, very seasonal, where if you're doing beef, you're talking something year round. That, to me, that would
Yes,
have
sir.
an impact on
And
it.
if you wish to make that, if you choose to make a ruling on this, favorable ruling, we'll say,
And we
you
can do
choose
that
to-
based
choose
on
to further restrict
testimony
that
given by the
down
applicant.
based on testimony, I will make sure it gets in the minutes, and that way, if it ever comes up again, somebody wants to do a butcher shop or a beef
And just-
processing, we'll say, no, you gotta go back to the Board of Zoning Appeals.
Just on a side note, you know, you can't do beef and deer at the same time, so the people that do both, they only do beef after deer season. You're not allowed to process at the same time, deer and beef at the same time. I know a guy up in Whitleyville that does that. And so during deer season,
All right,
that's all they
let's-
can do is deer.
Let's try to move on here. The floor is open for a motion in regard to 4160.
I'm willing to, I wanna make sure I really understand what the request is. He's requesting that he not have to pave and he not have to have the sewer upgrade or change, is that correct?
Because you're saying he's already got approval for the process.
Yes.
Yes.
He just,
The
now he's back.
holding tank was
Hold on,
in.
if you would, please, let us discuss this, because we sort of closed the public comment period. Let us talk. So he's already got approval for the process.
Mhm.
This is a request to do away with landscaping or paving. That's all.
It's a request to do away with the specific commercial requirements that he doesn't want to meet, which is paving and sewer.
He doesn't,
Paving and sewer.
Sewer and paving.
Sewer and paving.
Do what?
he doesn't want to do this.
Yeah, sewer and
That's the
paving.
stipulations he doesn't.
So
He
he's already,
doesn't wanna have to pave.
he's already got approval for the process.
Right,
He does not wish to have to meet the sewer requirement or the paving requirement for his business. That's it.
And the sewer requirement is what specifically?
That he's got to hook to public sewer, and he does have a problem in that the Water Authority and the Water and Wastewater Authority of Wilson County and the City of Lebanon have an agreement whereby outside the city limits in the planning region, the Water and Wastewater Authority typically will not serve their form of public sewer in that corridor. It's left for Lebanon to either serve by annexation or service outside of their city limits for public sewer.
Okay. So we've got these two things to consider, sewer and paving. Gotcha. Okay. Do I hear a motion in regard to 4160?
Mr. Chairman, I'm gonna move that we, grant the applicant, based on the testimony that he's given, number one, it's only gonna be for deer processing, that we grant the applicant relief on the paving and the public sewer requirement.
I have a motion to grant the relief for sewer and paving requirements based on the applicant's testimony that this facility is only for deer processing. Do I have a second? Motion fails for lack of a second. All right, the floor is now open for a new motion. In regard to case 4160, I'll move that we deny the request. Do I have a second?
second.
I have a motion and a second. Any discussion on the motion? If not, all in favor of the motion vote aye. Aye. Opposition vote no,
No.
and the ayes have it. So the motion to deny carries 4 in favor, 1 opposed. Thank you, sir.
So in closing, he has the ability to establish a deer processing facility there per your previous approval, but he has to meet commercial standards.
I think everything stands as it
Yes.
was, as I understand it.
All right.
I mean, can I speak?
No, sir. We have other business to do, and public comment is closed.
There's a misunderstanding.
Our next case is case 4161. Nicole Jackson is requesting a variance of 5 feet from the north rear yard setback requirement of 10 feet. The variance will allow the proposed detached garage to be 5 feet from the north rear property line. The property is located at 1041 Singing Spring Court, Lot 4, Horseshoe Cove, Group A, Parcel 8 on Wilson County Tax Map 31. D, the property consists of 12,605 square feet and is zoned R1 residential. We get staff recommendations on 4161.
Mr. Chairman, the applicant is requesting a variance of 5 feet from the north rear yard setback requirement of 10 feet for a proposed accessory structure on a corner lot. This is not an older tract of record, with the lot being created on May 17th, 1988. Therefore, given the language in the zoning ordinance, staff cannot recommend approval.
Okay, who's here to represent 4161 Jackson? Name and address, please.
Nicole Jackson, 1041 Singing Springs Road.
And what would you like to tell the board?
Well, I mean, we just feel like in the city you have the 5 feet variance, and so we were just gonna ask for the 5 feet versus the 10 feet to build our garage, just to store cars, and so they wouldn't be in our driveway.
So the variance request is so you can add an additional building?
Yes.
I got you, okay.
In 1988, when the lot was created, the requirement for accessory detached structures was 5 feet, but it was also 5-foot separation from the building, from the other buildings on the property if it was detached at that time. Now, we require 8-foot separation wall to wall, which is actually better than the 5-foot separation because previously it was eave to eave. And then 10 foot from the side property line.
So the setback requirements have changed.
For accessory structures since 1988 when the lot was created.
But you're saying that the building separation has actually gotten more lenient.
Well, building separation from another building, depends on how you look at it, but it's got more exact. It's 8-foot wall to wall because eaves can be different depths.
Well, that's what I was
Yeah.
gonna get to, was the eve width could make your situation worse or better.
Yeah. And then, but the probably the more pertinent thing that they're asking for is to be 5 foot from the side property line, right? And that's what the accessory structure was, requirement was in 1988 when the lot was created, but this building is a new building. We don't really have any way to apply that.
But I thought that that's one of the things we're here for.
That is, that's something you can determine.
Because the law has changed
Mhm.
and is more stringent against these folks than it was when the lot was created.
Yes, sir. And that is something you have the right to determine.
So that being the case, why did you recommend against approval?
Because of what the ordinance says, and it's a new building. It's not a replacement to our knowledge.
If the
Gotcha.
structure was existing, it would be grandfathered.
I got you. Okay. Yeah, that would pertain only to the existing home, not a new proposed
Mhm.
structure. Got you, okay. All right. Does the board have any questions for the applicant?
There's not an issue between a house and the new structure, correct?
Not to our knowledge.
Okay.
And part of why we even brought up the whole, or I brought up the whole 88 thing is there may very well be other existing structures that were built sometime prior to when we made that change in this neighborhood that are 5 foot from the property line. So that's something that you can consider. But per the letter of the ordinance and with it being a new building, we didn't feel we could recommend approval.
Okay. Other questions for the applicant from the board? Anyone? Go ahead.
One really quick, maybe, being a corner lot has no bearing on any of this?
Not for an accessory.
Okay.
For a primary structure, if you were talking about those setbacks, it might.
Well, I was just wondering if being a corner lot, she had to set further back from one of the lots and that therefore she's got less room. I don't know that, I'm just asking.
It's, the accessories are 10 feet from a side or a rear.
Yeah.
So on a corner lot, as long as she's doing the rear, it's gonna be the same whether it's a corner or not.
I guess what I'm saying is maybe because it's a corner lot, and she have 2 front yards and therefore had to set further back.
Set
from
the house
road.
further back.
Therefore, she's got less room in her backyard, is what I'm asking.
That would be accurate.
So that's what I was trying to get to.
Is there any real adverse effect
No, sir, I don't, my staff actually did the field review. Did you see any adverse effect on the ground?
No, they've got a fence already, and it's not going to take that fence down, that goes all the way to the property line. The neighbor was not home either, so I wasn't able to approach them, but they did receive a letter in the mail, and I've not received anything from them.
Gotcha. Okay. All right. If there are no other questions for the applicant, does anyone else here wish to address 4161 Jackson? All right, come forward, please, sir. If you would, let him have the podium, please.
Yes, that fence that's on the front side is coming down.
Okay, if you would, give us your name and address.
Sorry, my bad. Randall Jackson, 1041 Sing Springs Road, Mount Juliet, Tennessee.
All right, sir. Is this your property?
Yeah, it's our property.
Okay, you're with her?
Mm-hmm.
Okay. go
I
ahead.
am. So what I wanted to do, I wanted to make a garage that was 18 foot wide instead of 15 foot wide, because originally I was going to do it 15 foot wide and meet the 10 foot setback. So I need a little more room to park something else in there, but I just wanted to, like I said, that in that 5 foot, actually I could probably get away with less than 5 foot as far as requirement, because I just wanted extra leniency as far as just a little more playroom right there, so I know I was within all of the specs that y'all required. So,
All right. Gotcha.
so like I said, everything would be, of course, we'd have our stormwater done, and we'd have all the drainage to be ran right according to what y'all required for that. And I got like I think 12 foot from the back, and I also have 8 foot from the house as far as from wall to wall, is what I'm planning on. And that front fence is coming down, and the other part of the fence is coming down too, probably because it's already rotted and deteriorated. So we're just going to do away with the fence altogether on that side.
Gotcha. Okay. Anyone else here wish to address 4161 Jackson? Okay.
Our next door neighbor, he's already approved it.
We have submitted all this stuff to the HOA.
The HOA's already approved it all.
I got you. Okay, thank you. All right. Anyone else wish to address 4161 Jackson? All right. No more questions for the board for the applicants? All right, we'll close the public hearing. Thank you very much. And turning to the board, do I hear a motion, or do we need to discuss anything?
Mr. Chairman, I will move that we approve this case based on the fact that there's maybe somewhat of a hardship because it's a corner lot, and we've got maybe 2 front yards, and therefore had to set further off the road.
Okay, I have a motion to approve 4161 as stated. Do I have a second?
I'll second.
I have a motion and a second. Any discussion by the board? If not, all in favor vote aye. Aye. Opposition vote no. And the ayes have it. Thank you. All
Mr.
right.
Chairman, case 4162 was withdrawn,
And 4163 deferred.
and 4163 was deferred. That's correct.
Okay, so we're ready for 4164.
You ready for my staff comments?
I'm not, I haven't read it yet.
Okay.
Get my paperwork right over here. All right. Case 4164, Randy Anderson, on behalf of Oxshire Properties LLC, is requesting a variance of 23 feet from the front yard setback requirement of 60 feet and to waive the commercial requirements listed in section 3.41 and 3.55. The structure is 37 feet from the property line. The property is located at 10440 Central Pike, a portion of parcel 17 on Wilson County Tax Map 99. The portion of the property consists of approximately 40,000 square feet and is on C1 Neighborhood Commercial. Now we'll get staff recommendations on 4164.
Mr. Chairman, the applicant is requesting a variance of 23 feet from the front yard setback requirement of 60 feet and is also requesting to waive commercial requirements listed in 3.41 and 3.55 of the zoning regulations. This property had a commercial market on it that predated the commercial standards listed in the zoning ordinance. In fact, it probably predated the zoning regulations in general. The applicant met with planning staff regarding remodeling the existing structure. During that meeting, the applicant was made aware of the market's grandfather status and was informed that the property could be remodeled without issue. They were also informed that tearing down the existing structure would result in the loss of that grandfather status and make them subject to all commercial requirements listed in the Wilson County zoning ordinance. The applicant proceeded to tear down the existing structure and replace it without obtaining a building permit, which resulted in a zoning violation that has brought them to this point of coming before the board. The new structure does not meet commercial building standards for parking, landscaping, building materials, or connection to public sewer. Therefore, given the language in the zoning ordinance, staff cannot recommend approval.
Okay. Who's here to represent 4164, Randy Anderson? Yes, sir. Name and address, please.
Randy Anderson, 3588 Linwood Road, Watertown.
What would you like to tell the board, sir?
All right. Initially starting out, it was planned to just remodel the existing building that was already on site. The biggest thing was taking off the existing roof. It was a block exterior building, so we was just gonna paint the block, but mainly replace the roof. Well, once the roof was demoed and removed, none of the block were core filled, so you could kind of lean up against it. Walls were shifting to the point where it was not far from falling. So that's probably where the mistake was made. Didn't get back to pull a permit. We already had the truss package, on the ground. So we tore down probably around 6 to 7 feet of the walls. We left the existing foundation, probably 4 to 5 feet and areas all the way around the building. So never actually tore it all the way down. We just did tear the walls down by about 6, 7 feet all the way around the building, so we could core fill the block, pour a cap, new sill plate, and put it all back together. So that's kind of what got us here. I think the mistake was once that roof came off, it was more damage to the building than expected. So you can see in the photos, all the block that's painted green, that's part of the existing structure. So we just kind of had to build what was initially going to be a little knee wall, enough to tie a new roof onto the block. It just became bigger walls.
And what is this still a commercial market, or what is it?
Yeah, they're wanting to make it a convenience store.
Convenience store.
Yeah, so just a little convenience store.
What was this before? What was
I think it was like a motorcycle bar or something.
It's been several types of tavern, motorcycle
Is this down
bar.
close to Loeb Road?
Yes.
Yeah,
It
it's
used
the
to have
east of
graffiti on the
Loeb
wall.
Mm-hmm. Yeah, it had the graffiti all over the block, which we painted over that, but
But you acknowledged that you met with staff and they told you if you were gonna
Yeah, so
demolish this
we had-
building, you would have to, that you would lose all the grandfather. status.
Right, yeah, so we had initially, like I said, our initial plan wasn't to demolish anything except just replacing the roof. And then once that roof came off, that's where everything kind of changed.
Yeah, but you didn't come back, talk to them about it, get a permit, have any further discussions or anything?
We did.
Is there public sewer on site?
No,
road?
I don't believe so.
So how does that work?
It would have to be a step system. And I'm sorry, I do not know, I don't think this is in
I thought
Lebanon's planning region.
Wasn't this the
Ma-
parcel that a
ma-
gentleman came up here a couple of years ago and was gonna make a church?
That's next door.
That's next door, okay.
It was a part of the same parent owner, but he's that was over here.
Okay, this is the, well, this is, used to be the loose caboose.
That's,
That's
no,
that's what,
I don't know.
yeah, it was the loose caboose.
Yeah.
That's what that was.
That's loose caboose.
That was on my mind.
I'm just giving reference to the location.
Did you freak it off?
No, I didn't do that. Okay, so anything else you'd like to tell the board, sir?
That's it.
Board have any questions for the applicant?
When I look at this as violations, and you're talking about sewer and all these other building materials, landscaping, what's your proposal for that?
Right, yeah, I guess to waive it, like I said, the structure's done. We completed it back in October. The property owner, I think, they had a couple violations through the process that we was unaware of until October. So I think that first notice of violation that came out in like June, and we was in the middle of the project and nobody was aware we had any kind of violation going on. So didn't get that till the project was complete, and it was about a week after that, he had notified us, hey, I got a code violation, and we're like, what? So we immediately contacted, Stormwater, you know, just trying to get the process started of, all right, how do we go back and get all this stuff made right? And got Charlie Dean with, Dean Design Group to start coming up with the site plan, you know, getting all that, which I think he's coming to the meeting tomorrow for, to see if, depending on how this goes, you know, to try to get that approved. And so then, you know, eventually notified Karen, you know, hey, how do we make this right? You know, let's start
So
the
this
process.
First
So
notice of violation, June 23, you've never seen
Right.
this.
We did not see that until October, I think it was like October 12th.
But the owner received,
The owner receives the
Mhm.
letter. The letter's sent out to the property owner.
Yeah.
but he never notified you of the violation.
Not until October, or we would have stopped the progress immediately, you know, trying,
Right.
didn't wanna open that
Okay.
can of worms for sure.
But the owner received, the owner of the property received the notice.
Yeah, so there's two parcels there, I guess you could say. There's one's 10-430, one's 10-440. Neither one of them have any, I don't know if they have a mailbox or what, but it was sent to that address, and I guess it was just months later before they even got it. Cause when I asked that property owner, hey, you got this notice in June, why am I just now getting it in October? You should have told us months ago. And at that time, he was saying, my team just received it as well. So I don't know if it was in a mailbox or, you know, not sure exactly where it went or why it took the property owner so long to get it.
Well, if it was
also.
undeliverable, the post office would have sent it back
Right,
to the building
right,
office.
yeah.
Mr. Chairman,
Yes, ma'am.
I did have conversation with a Sam Ray. The complaint came about because I spoke with Daniel Cowan, because he had gone by there and told me that it was a totally new structure. So, that's how the complaint came about. And then, I had email conversation with Sam Ray at New Day Construction. And he apologized for the confusion, and then he sent pictures in regards to what was tore down. I'm not sure if I placed those in your packet, if you'd like to see them. But there was the structure where it was tore down.
Yeah, so that's about how far we had to go down to core fill the block.
Yeah,
you know,
so I
just to
did
core
have,
the cap.
I didn't have any conversation until like September with the Samuel Ray. And told him that he needed a permit.
So if they hadn't torn it down, had they just, you know, painted and refurbished and whatnot, everything would have been grandfathered in and
Yes, sir.
they'd have been good.
Yeah. Because that structure literally, I think, predated the zoning ordinance.
I'm quite sure it did.
Yeah.
It was 1940, I think, was the existing.
But I don't see any proposal in here, maybe I missed it. I don't see any proposal in here of actually how you intend to, based on where you are, how you intend to meet or any alternative to meeting these standards. I see a lot of notice of violations, and I see a survey and maybe a little plot plan. But for instance, do you have anything that signs off on the sewer, the existing sewer system?
Right, yeah, so it is a private septic, and we're working on getting an inspection letter now from
Right, but
TDEC.
you don't have an inspection letter
Right,
at this point.
right.
No, the only septic that was able to be found, looked like it was for a trailer. It wasn't for that structure.
For the commercial use.
They do have a site plan submitted to planning tomorrow that I was just talking to my staff about, that we are still in need of some corrections to with regard to limiting down their unlimited curb cut that they currently have. They do show paving in portions of it, but they do not have public sewer requirement. They do not have a landscaping plan at present, and there was something else. Yeah, the building material they're proposing is hardy board, which is, that's something the planning commission will have to consider whether they're gonna accept or not in this circumstance.
I just,
Is this new, excuse me, go ahead, Mr. Cross.
it's hard, I think those situations need to be corrected and addressed before we,
Well, I'm sort of thinking we need a proposal, for example, how
Exactly.
you going to deal with all. For instance, I see on these pictures that you have an exhaust hood on the roof.
Right.
So they're gonna be, it's a convenience store, they're gonna be cooking and
Yeah,
carrying on?
so initially they was that,
So they're gonna have a grease and
No,
there's no
they're-
grease pit here?
they're
or-
not any longer.
No?
So they was going to initially, and that old building was a big commercial hood, and they was like, hey, we wanna save that, you know, it's kinda, we can clean it up a little bit. So we saved it and remounted it, but there's gonna be no commercial kitchen, anything in it. It's just cold drinks, chips, like just a convenience
Is the
store.
hood installed?
The hood is installed, but we can take it down if need be.
I would think public sewer would be a big issue. Seemed like about 30 minutes ago, we wouldn't grant somebody killing deer public sewer, and this right here is gonna have a ton more foot traffic. I mean, a ton more
I
than
mean,
somebody killing a handful of deer. But that's just
The-
my thought on the matter.
the only, and unfortunately, Mr. Luber, I don't think is here today. He's usually here for planning commission with the Water and Wastewater Authority, but to my knowledge, outside of city limits, that's probably their best option for a public sewer provision there.
But this was an existing commercial use for 60, 70 years.
It lost all that,
all it's ever been. It's a commercial use.
but he lost all that when he tore it down, did he
But
not?
he didn't tear it all down.
I got a question.
You're all quiet.
I got a question.
Yes,
You
sir.
know, when it was a business previous, whatever it was, what did they do about bathroom facilities?
I don't know, you weren't
We
one.
don't know.
I didn't go there. I didn't either.
It did have them, so it had bathroom facilities when we started the demo process of just cleaning the building out. It had 2 restrooms already on it. And there's an existing septic tank behind the building, probably 30 feet off the building. So that's why we're just trying to get that inspection letter from.
The building has a colorful history, but, or had a colorful history.
Doesn't seem to have changed much.
Huh?
It doesn't seem, it's pretty colorful in itself. It
Yeah.
doesn't seem to have changed much.
I
Because
don't
I
know if one wall justifies a structure. It wouldn't to my wife, I moved in it, so.
Okay. Does the board have any more questions for the applicant? If not, does anyone else here wish to address 4164 Anderson on behalf of Akshar Properties? Okay. That being the case, I'll close the public hearing. Thank you, sir. And move to the board for further discussion or motion.
I'm making a motion that we deny based on, staff recommendation.
Have a motion to deny based on staff recommendations. Do I have a second?
I'll second.
Have a motion and a second to deny based on staff recommendations. Any discussion on the motion? If not, all in favor vote aye. Aye. Opposed, vote no.
No.
All right. Motion to deny passes, 4 in favor, 1 opposed. Okay. Our next case is case 4165. Angie Higgum is requesting the use of property for storing or parking of boats and recreational vehicles. The property is located at 7325 Lebanon Road, Lot 2, Cantrell property, parcel 17 on Wilson County Tax Map 55. The property consists of 4.36 acres and is zoned A1 agricultural. We get staff recommendations now on 4165.
Mr. Chairman, the applicant is requesting to use the property for storing parking boats and recreational vehicles. RV and boat storage is not a permitted use or a permitted use on appeal in the A1 zone district. Given the language in the zoning ordinance, staff cannot recommend approval or recommends denial. Staff will note that the applicant has appeared before the board for the same property back in August of 2023. The applicant had requested to use the property at that time as a wedding venue, but the request was denied by the board.
Okay, who's here to represent 4165? Yes, ma'am. Add the name and address, please.
Angie Hyam, 7325 Lebanon Road, Mount Juliet.
And what would you like to tell the board, ma'am?
That the picture that you guys have up there, we've made that area, we've cleared it up and cleaned it up and leveled it out. And we have proposed to park some RVs backed up to the tree line, so it
Like-
wouldn't be down the middle.
Is this your property? I guess, did this come from staff?
Yes.
Okay, staff.
I believe, yes.
There you go.
You can come closer and look at it.
My eyes aren't going very good anymore.
Okay, anything else?
We are going to widen the entrance, if given permission, from Lebanon Road into the driveway and asphalt that in 75 feet off of Lebanon Road and place a gate when you get in the 75 feet.
Okay.
That would require a TDOT permit, I believe, because it's a state route.
Some of the neighbors have already asphalted in, I think, just because you know, it's a cleaner look, makes it nicer for your own vehicle proceeding in and out of the drive.
Does the board have any questions for the applicant?
The RVs on here now is campers, is that?
Those are our
yours?
personals, yes.
Tom, in what zoning is this allowed, or?
It's a violation. Sorry.
What zone is this use allowed?
Boat storage would be industrial, in C2 on appeal.
C2 and I1. Any other questions for the applicant? If not, does anyone else here wish to address 4165? Higgum Boat Storage. Okay, then we'll close the public hearing. Thank you, ma'am. And turning to the board for a motion or any further discussion? Ready for a motion on 4165?
Mr. Chairman, I will move that we deny this based on staff recommendations and the fact that this use is not allowed in a A1 zone district.
Have a motion to deny 4165, not an allowed use in the district based on staff recommendations. Do I have a second?
Second.
Have a motion and a second. Discussion by the board. If there's no discussion on the motion, all in favor vote aye. Aye.
Who made-
Opposition vote no. The ayes have it.
Who made second?
Sonia.
Sonia Robinson. Okay. Our next case is 4166. 4166, the Barn Store, on behalf of Peyton McCullough, is requesting a variance from the accessory size requirement of 138 square feet, a variance of 5 feet from the west side yard setback of 20 feet, and a variance of 15 feet from the rear yard setback requirement of 40 feet, and a variance from the lot width requirement of 125 feet. The variance will allow the property owner to build a barn that is 900 square feet, 15 feet from the west side property line, and a variance of 25 feet from the rear property line. The property is located at Lago Vista Drive, Lot 123, Coles Ferry Camp, Group B, Parcel 24, Wilson County Tax Map 14N. The property consists of approximately 4,600 square feet. We get staff recommendations now on 4166.
Mr. Chairman, the applicant is requesting a variance of 138 square feet regarding the accessory size requirement of 2,000 square feet. The zoning ordinance states that accessory structures on lots in A1 zone property that do not have a primary residence on them shall not exceed 3% of the total lot area with a maximum size of 2,000 square feet. Therefore, given the language in the zoning ordinance, staff cannot recommend approval. The variance requests that were listed have to do with the fact that, again, on a lot without a primary structure, primary residence, an accessory structure has to meet the primary setbacks. So if they had a residence on that property specifically, or on that lot specifically, they could be within 10 feet of the property, side and rear property lines. I believe this is that the house that the gentleman
Yeah, that's the resident.
owns? And this is the lot. There's a old lake access type platted lot here. This is a really old subdivision. And the applicant did submit photos to us showing that he's simply trying to replace a pre-existing barn that he's since knocked down, but he's showing that barn was there, and this is a replacement.
Okay, is this, Tom, what happens with these old lake access points this day and time? Are they still there, or are they dealt with, or?
Yes, they're still there. The road commission has done various and sundry things with them. I'm sorry Mike left. But they including ceding the county's interest if they have any in it, but he's always quick to say, it's kind of like us ceding our interest in McDonald's down on West Main Street. If we don't have any interest to begin with, and we quit claim deed our interest in McDonald's on West Main Street, it really doesn't do anything. But those lake accesses are still there because they're there by plat, and they show up on our property maps most of the time. Hey, Mike, we were talking about old lake accesses, if you've got any input.
So,
All I've had to deal with them here lately, they've been in trouble.
Yes,
so the situation is, the lot itself is grandfathered,
yes.
but why did they not get a variance on the why did the grandfather not apply to the 3%?
I guess because it was a new building, and we didn't have knowledge
Again,
about
okay, again,
we
new
didn't,
building.
we didn't have knowledge of until the applicant submitted it during the review process, that there was a barn there that he, I guess, relatively recently knocked down.
If they wanted to build a residence on this, would they, get some relief on variances because it's an old lot of record?
Yes.
So why would that not apply to the barn? Or it could, I guess.
You could.
We're not denying the fact that he could build an accessory structure. He could pull a permit for that now, but there's
Just the
still the
size.
size
Yeah.
stipulation based on the lot size, because there's not a residence.
And it's relatively minor, it's 138
He can get
feet.
it.
Right, and it's a relatively small lot, it's 4,000 square feet,
Right.
it's a tiny lot.
Gotcha.
Yeah.
Okay. All right, so we've got staff recommendations. Who's here to represent 4166? McCullough.
Austin Christian, 660 Coles Ferry Road, Gallatin, Tennessee. The owner, Peyton McCullough, is actually here. I don't know if it's okay for him to come up at the same time, or if you want to wait.
I'll hear from either one of you. We will, whatever order you want to speak.
Okay. So, yeah, essentially, you guys hit the nail on the head. We're essentially going out there to try to replace an existing building that was already there. It was old and dilapidated, wasn't really of much use. The most interesting thing about this property is that Mr. McCullough actually owns those four lots where that house is sitting on directly to the left.
So
Of this
1,
lot.
2,
So the
3,
only
and
thing-
4. 1, 2, 3, and 4.
Yes, sir. So, you know, in terms of the way that this property lies, if that lake access or old lake access wasn't necessarily there, if, I guess essentially 4 property lines were abolished, then that becomes one huge lot and meet all the requirements for the size of the structure. But in this particular case, to not necessarily have to have a brand new survey done and lines abolished, you know, we were basing everything based off of there being an existing structure that was already there that we're essentially going to replace.
Does the board have any questions for the applicant?
The new barn or storage or whatever will be strictly for personal use of the owner?
Yes, sir. Yeah. So on the house here, there's if you were able to pull up the 3D view, it's a basement home, and the way that the land lays, if you come off this, where it juts out to the left, this driveway, there's actually no access whatsoever to even get down to where there's a single 8x8 garage door, really small garage door, which he can't even use it for access to park his vehicle. So currently he's having to park in his gravel driveway.
out in front of the house, so it would strictly be for just personal use to be able to park his vehicle inside.
There's no sewer with that property, is there?
Sewer, is there sewer? No, is it sewer or septic? It's
For
septic.
this lot, there's a septic system.
No, there's not a septic system for that lot, right?
Not on that lot.
Okay.
The septic system is on the adjoining lot, the farthest lot that joins the right of way.
Okay. Any other questions from the board for the applicant? If not, does anyone else wish to address 4166 Peyton McCullough? Yes, sir.
My name is Charles Pass. My address is 115 Chapman Drive here in Lebanon. I am also the owner of the adjacent property next to Peyton's property, and I just wanted to go on record to say that I have no problem with the setbacks being approved for him to do what he's wanting to do out there.
All right, thank you. Appreciate that. All right, anyone else? If not, we'll close the public comment on case 4166 McCullough and turn to the board for a motion.
I'll make a motion to approve.
I have a motion to
Variance.
approve 4166 for the requested 138-foot variance. Do I have a second?
Second.
Have a motion and a second. Discussion on the motion? If not, all in favor vote aye.
Aye.
Opposition vote no. The ayes have it.
Who made motion and second?
Crockett made the motion, Blades made the second. All right, hold up just a minute. Everybody good? You want to take 5?
Just take 5.
Okay, we're gonna have a 5-minute recess, and then we'll come back and deal with the rest of the agenda. If I could, please call the meeting back to order. We'll try to continue with our agenda. The meeting is back in session. We'll now continue with case 4167. Cameron Shepherd is requesting to use the property for parking commercial vehicles for a heating and air business. Applicant is also needing a variance due to the property being subdivided without a recorded plat. The property came of record September 17, 1980. The property is located at 2055 Holloway Road, a portion of Lot 7, Dunaway property, parcel 35.08 on Wilson County Tax Map 102. The property consists of .79 acres and is on A1 agricultural. We'll get staff recommendations now on 4167.
Mr. Chairman, before I start with my written comments, I will say this is a property that we have been in on a time or two for zoning enforcement at the request of different plaintiffs or complainants about the operation of a potential business on the property. My first dealing with it was last, I think, July, I believe, of 23, and I did speak with the applicant at that time and talked with him at that time about the sort of the thresholds between operating a home occupation versus an out-and-out business on a residential property. With that, I'll start with my comments. The applicant is requesting to use the property for parking commercial vehicles for a heating and air business. My staff, during field review, did speak with the applicant on site, who stated to my staff that he was willing to have all of his employees keep their trucks, their commercial vehicles, off-site, which would remedy the commercial trucks on the property, with the one exception being his personal work truck. The applicant also stated that there's no storage of units or material on site besides what may be being installed on a job that day, but that equipment would never come off the trailer. So I'm assuming what that means is he might have a truck and a trailer with a HVAC unit on the back of it, and he wouldn't be unloading it at this property. It would just be there ready to go for the next day with his individual work truck. If the applicant is to agree on the record that all work trucks are to be kept off-site and all equipment is to be kept off-site, other than that, that's been stated to my staff, and that there will be no storage of HVAC materials on site. Staff feels that this would fall under the home occupation provisions, and the board would not need to take action on the request. There would be a home office on site, but that utilizes less than 25% of his home floor space. So long as it used less than 25% of his home floor space, it would still be in keeping with home occupation, subject to the property being used as a residence. If the applicant chooses to pursue the commercial truck parking on the property, staff would recommend denial, as this is not a use allowed in the A1 zone district.
Okay, who's here to represent 4167 Shepherd? Yes, sir.
Yes, sir. My name is David Wood. I'm an attorney in Nashville. Mr. Shepherd is right back here for any questions. He's just asking me because I do real estate law. Thank you for taking the time to serve on this board. And as the staff noted, we are happy not to park any commercial vehicles on this property, but we also don't want to miss this opportunity to address any other concerns the board has. And I know that in other zoning boards, there's often approval with stipulations if there's particular concerns about the property. So we are happy to address any other concerns the board may have and just understand more about this property.
Thank you.
I will state, just from, I told you we've been out on several enforcement visits. At different times, we've asked them that we saw a need, that there were some things that needed to be cleaned up about the property. The past several times I've been by the property, it has maintained a relatively clean appearance. There's not a lot of boxes or debris or HVAC, piles of old HVAC ductwork or new HVAC ductwork for that matter, or anything piled up or hanging around. I do think that there's an ongoing property dispute that may be fueling some of the complaints. That just has to do with some personality issues and some opinions that there is in fact a commercial operation at this location. So,
Well, the fact is, if Mr. Shepherd's bringing his own work truck home and parking it in his driveway, that's not an issue.
no.
And if he's doing something other than that, it might be.
Yes, sir.
So, okay. Does the board have any questions for the representative of the applicant?
This handout we have, these pictures in the very back, what location are these?
Of other properties in the
photos?
area?
Okay.
I think,
They're not
yeah.
this location.
No, there are other properties in the area. There are a number of egregious violations in this
Yeah,
area.
okay.
Several of which are being processed.
Beg your pardon?
Several of which are being processed by
Okay.
zoning enforcement.
But it's not your particular?
No, sir.
Okay.
Okay, does the board have any questions? So what you're telling us is that Mr. Shepherd's gonna park his own vehicle there, and that's gonna be the end of it? His own personal vehicle he drives, or his own work truck that he drives back and forth to work?
Yes, sir, at a minimum. And if this board does not,
Not at a minimum, at a maximum. That's gonna be it.
correct, so there would not be, yes, we would not park.
That
it.
being the case, staff says it's a home occupation and we don't need to take action.
Okay, there's no permit required for the home occupation or any other stipulations?
Not if that's what it's deemed, no. But if it gets to be more than one truck, then I think that would trigger some further discussion. Okay. Anyone else wish to address this case? Commissioner?
Yes, sir. Mr. Chairman. Haskell Evans, 5925 Franklin Road, current District 12 Commissioner. I'm here today to represent a property owner adjoining Mr. Shepherd, who's not able to be here today on account of having surgery. He wrote up a statement and asked me to read for him, and asked me to submit some pictures to the board for their consideration in the matter. And with your approval.
Sure.
He has
Thank you.
kindly added post-it notes to each one to give it a little context there.
The gentleman you're speaking about, is his photos in the back of this?
Is looking at the picture, his property is to the right.
Okay. But his property's not included in these pictures here in this packet we have?
That's correct.
Okay.
I think Mr. Shepherd submitted those photographs as other violations in the area.
So I will read the statement. To the zoning commission, my name is Warren D. Jenkins, 2025 Holloway Road, residence directly beside 2055 Holloway Road, where a full-blown heating and air company, K&S Heating and Air, is being ran out of a residence. This company is owned by Cameron Shepherd. Mr. Shepherd has been operating illegally out of this residence for a while. Several complaints have been filed by myself with codes, and I've met with Mayor Hutto 3 times and Mr. Brashears at least twice. 2055 Holloway Road consists of a 2-acre tract of land cut off Dunaway property in 1980. I'm not getting the .79 acres supposedly subdivided, nothing on record, no separate mailing address. I know this is not y'all's thing. My home is very close to Mr. Shepherd, unfortunately, and has been a nuisance ever since he started this venture. It has grown into a good-sized business with at least 8 to 10 service vehicles. What this means is if there are 10 service vehicles in the yard, plus the 10 vehicles that the employees drive with the personal vehicles, now we have at least 20 vehicles on property at any given time, not counting delivery trucks. Unfortunately, this will not be used only for parking. Work is being performed on property, product is being warehoused in shop, old units are being disassembled for junk, gas and oil out of compressors is being drained, and with odors at times being so strong, I'm wondering where they're being drained. Trash, cardboard boxes, and pallets are being burnt with smoke and debris flying everywhere. The noise level gets pretty loud with the beating and banging at times. Ductwork is being assembled in shop for unit installation. I have tried to take photos and video without causing problems. My home is 70 feet from shop. My patio, you can hear everything, including conversations. Everything seems to be amplified. The driveway entrance is very close, with delivery truck with air brakes and backup beepers going off. It really annoys my animals. The employees seem to realize this and blow the horn entering and exiting property since I have raised so much cane. It all boils down to this is not zoned for commercial use of any kind, especially a business of this size with several employees and equipment in and out and still growing, which I wish Mr. Shepherd well. I am sorry that this has fell into you folks' lap. The codes and county attorney should have already taken care of it. I understand, try to save money, but not at other folks' expense. We have chose to live in the country for a reason. I'm sure Bentley's Heating and Air and Bradley's Heating and Air would love to do the same, not meaning to sound sarcastic. This affects all of Holloway Road as a whole, not just the 4 or 5 people that got letters. This is not the place for commercial businesses whatsoever, and I'm sure no matter how you rule, this will not be the end of this. I have already seen and experienced the way Mr. Shepherd operates with no regard to neighbors or the county codes and zoning. Thanks. I am sorry I couldn't be at the meeting. I'm in Vanderbilt having liver cancer surgery. Thank y'all. That is the statement from Mr. Jenkins. Further, I want to point out that Holloway Road is 3.5 miles long with 121 residents and is all zoned A1 or R1.
Thank you, Commissioner. Anyone else wish to address this case?
Mr. Chairman, go ahead.
Yes, ma'am. Come on. Give us your name and address.
My name is Wendy Pinkley. I actually live on East Richmond Shop Road, but I'm speaking on behalf of my father, whom Haskell was speaking for as well. He would love more than anything in the world to be here today because, unfortunately, he's had to retire early. And I'm going to kind of hit on this on a personal note. They've raised our kids, meaning their kids, 4 kids, 7 grandkids out there, and with the in and out of the traffic of the delivery trucks, I mean, it's just not even, the road is not even big enough for that type of traffic. You know, I mean, if you're just coming to and through, but it's one thing, but if you're going in and then pulling out and doing all this, it's actually kind of a accident waiting to happen, should I say. Because that road is very curvy and meticulous, and you have to be careful. There are no rails or anything. It is a very old country road. They have sat on their porch, and we have seen soot come over, and I know everybody burns something. I get that. I live on by the Cedar Forest. I get that. But it will literally come onto their patio, so that's probably the reason why they've been cleaning up is because they've been burning the boxes, if you want me to be quite honest with you. Other than that, I don't have anything else to say. Other than he is not going to be at peace because he is the one directly onto that property while he's going through his cancer recovery.
Thank you.
Thank you.
You have something to add, sir?
Yes, may I address the concerns that have been raised?
Yes, absolutely.
Well, these concerns certainly sound serious, but we can speak to the zoning violations that we were notified of. So certainly if there's further concerns, we're happy to address that, and we would very much disagree that we're not respecting county authority. We are here trying to address any problems that may come out. So we had notice of 4 vehicles, commercial vehicles on the property, and we are happy to remedy that. As far as 20 vehicles on the property, I don't see how.
I don't see how that's relevant at all.
I don't
You've already
see.
stated that he's gonna have only his personal work truck, whether they're 4 or 20, I don't see how that's relevant to our proceedings.
Correct, and then that's my view too. So we are happy to address any of these concerns, but like I said, this is the first time we've heard about it. They have not been brought to us by the codes or zoning commission, so it's kind of just one word against the other. But we would be happy to take any corrective matters that the board brings up at this point.
Thank you. Yes, sir.
I should bring up one other issue. I'm going to ask Karen, where are we in the enforcement process? I know one of them, I think Mr. Haskell, speaking on behalf of Mr. Jenkins, said that he had met with me twice and Mayor Hutto 3 times. After the last meeting, I did ask for my staff to go back out there, and I do think that they found something they thought was worthy of enforcement, and they sent another letter. I think it was a notice of intent to pursue court action, but I wanted to verify that.
No, it wasn't. It was
Oh,
the second notice.
Second violation.
So it
Okay.
was the second notice. of
So we did
violation.
send a second notice, which is why they ended up coming here to request the appeal, based on what enforcement staff found on the property.
If there's no one else that wishes to address 4167 Shepherd, I'm gonna close the public comment period. And there's none, okay? And we're gonna turn to the board, for a motion or further discussion.
Just this discussion, we have this packet, which is, I guess, part of their information. And so it says here on a typical day, 3 vehicles are normally stored. Now, is this what they're, I mean, you know, he said there's gonna only be 1, but yet the packet, they say, openly states there's gonna be 3.
That
So
would be
to me,
something
that
I
seems
would-
like that's a little bit of a conflict.
I would think you would need to get clarification on that.
Yes, because it,
Well,
you know.
They submitted this packet with their application. Representative and attorney says that's not what they're gonna do.
Okay,
They're
I
gonna
just
have
wanna clear that up.
his
yeah.
personal work truck only.
Okay.
Can I get some additional clarification from the attorney or from Mr. Shepherd? So my understanding is they may have been storing some equipment in this shed, and maybe even working in there per Mr. Jenkins' testimony through Mr. Evans. Are they going to continue to take shipments at that facility, or are they going to take shipments elsewhere?
Well, certainly not if it violates a home occupation. So part of the reason here is that Mr. Shepherd is very flexible. So it does say 3 vehicles there, but if this commission feels that that's not in line with home occupation, he's happy to make other arrangements.
Yeah.
So, and part of
The reason I'm asking for clarification is because there is a conflict here between neighbors, and we're unfortunately being brought into the middle of it repeatedly with potential zoning violations. Will not deny that, and we've been out and investigated them. At times we found some things, at times we haven't. But I would like to get clarification on what exactly Mr. Shepherd is committed to doing on the property, so we can determine, and this board can determine
Yeah,
whether or
I
not.
wonder though, just how many what-ifs do we ask?
Fair enough.
Because, you know, some of the policies of Wilson County, in my opinion, have allowed citizens, when they want to or can or judge to sort of weaponize the zoning ordinance.
Yes, sir.
Because we don't go out on folks unless we receive a complaint from the people, from a person or in the community. And I think that's not exactly the way to do things. And that's not new. You've heard me say that before.
Yes, sir.
Because what we've got here is a neighbor who says he's being disturbed by
Yes, sir.
commercial activity, and he says he deserves some relief, and he probably does. And then we have Mr. Shepherd, who has parked some trucks and maybe unloaded some equipment, and he wants to run his business and ensure his livelihood. And from looking at his packet, he says, well, I may be in violation, but I'm probably not anywhere close to the only person. And if you ride up and down Holloway Road, you can see he's probably the nicest looking violation out there. Because there's probably a dozen, and some of them are pretty ugly, and one or two of them, I understand y'all may be taking some action on.
Yes, sir.
But I think that is the result of a policy that I wish was changed. I wish we didn't have to rely on the citizens but because a citizen might report one violation on one side of his house and then decide not to report the violation on the other side of his house, just based on how he feels about the relationship. And that's sort of, I think, what you were getting at was, there's a relationship issue here, we need to clear it up, but at the same time, we can play what if all day long.
I
What if he
don't
stores some
think I can
equipment?
clear
What if
up
he does-
I don't think I can clear up anybody's personal relationship issue, but what I did want a little bit of clarification on was how much activity in addition to his, let's say, vehicle and pull-behind trailer on the properties are gonna be. Are there gonna be shipments
If
there?
he takes the position, he's a home occupation, that has to be up to your office to make that determination.
And we're trying our level best.
I mean, that's what
Yeah.
has to happen. You have to define the home occupation, and you have to hold them to it.
Yes, sir.
Anyway,
And if I may,
Sure.
I would thank the chairman for bringing that up. We would like to follow the rules. It's just that we want to know what the rules are.
Yes,
So
sir.
based on my reading of the zoning code, I think the nearest example in the zoning code is of surveyor. Like the HVAC company, a surveyor does not work out of his house. He goes and surveys other properties. Mr. Shepherd installs HVAC products at other properties. So the home occupation is primarily storage. And I don't think anyone on this board would say he's not allowed to leave his tools in his truck. And I also believe no one on this board would say he's allowed to build a sheet metal factory out there. So it's certainly a continuum. We just want to know what the limits of the home occupation would be so that Mr. Shepherd can stay in compliance.
well, I think,
with them.
that's a good point, and here's the thing. If Mr. Shepherd wants to bring home his truck at night, that's fine. If he wants to take something off that truck and put it in his storage shed, I don't think anybody would say anything about that. It's his material in his shed. When his business gets to the point that he's been so successful that he's gonna have 5, 6, 7, 8 employees and 4 or 5 trucks and this type of thing, he and everyone else who've been this successful may need to look for other facilities.
Of course.
That's just part of success. When you grow, you have to expand and you have to take on additional responsibilities.
Of course. And Mr. Shepherd is willing, even with the current level of success, to alter business practices. If the meeting of commercial vehicles at the property is a problem, there's a simple solution, as he's detailed in the business plan, that the trucks just go to the project first. So I absolutely agree with the chairman. There are steps that need to be taken if this is growing and be more successful, but we're also willing to take steps immediately.
Sure, okay. But back to Mr. Bashir's comment, this is work truck at home only, any material stored in the shed, nothing outside, no burning of pallets,
And I think that's-
nothing that would constitute anything other than a residence.
Y'all have stated how many shipments, like a shipment or 2 a day or something? Or-
What would you say is the shipments you get currently?
The only deliveries we receive are from any typical FedEx, Home Depot, like, Penske trucks, which would be Home Depot, UPS, Amazon. There are that property is unaccessible for sale.
Mr. Jenkins, I think, had one he said was from Ed's Supply, but it's a box truck. Yeah.
I mean, there has been.
If y'all could hold, we're getting testimony that's not come to the podium, I don't know whether,
That's
you can
true.
get it or not. Why don't you just repeat what Mr. Shepherd said, and let's get that in the record, and then we're gonna move on.
Absolutely. Mr. Shepherd said that the only shipments typically received are from common delivery services such as FedEx, box trucks, this Amazon. The property is not accessible by semi-truck and that he had received a shipment by box truck from Ed Supply. I believe that was encapsulating it, but
Just so we're clear, Amazon's one thing, FedEx is something, normally a smaller truck. When you get into semis and 40-foot box trucks, that's not a home occupation. Agreed?
correct. Maybe I was using box truck wrong. I was kind of imagining those as like, there are lots of box trucks, so I definitely understand that
But
we
if
don't
this-
want to fall too
If this
far.
comes back and staff says this is not a home occupation, when we're here a few months from now, that will not, they're gonna have some documentation with that, and that won't be,
Sure,
viewed as a home occupation.
sure.
All right. If no one else wishes to address this case, and if the board has no questions of the applicant, then I'll close the public hearing again. Okay. Now, moving to the board, we have two requests here. One is to use the property for parking of commercial vehicles, and I think we talked about that a lot. The other portion is that evidently this lot was subdivided back in the 80s, Karen, or back quite some time ago, without being properly recorded, and
Yes.
crossing all the Ts and dotting all the Is. So we have also here a request to declare this a legal lot of record. Did I put that right?
Yes.
Okay. So, all right. So those are the two requests that are in front of the board. Do I hear a motion?
Mr. Chairman, I will move to approve both of these requests, and the request is that staff is viewing this as a home occupation, therefore it must meet the guidelines as a home occupation. And then also I will approve
Well, actually, the request is to park commercial vehicles.
okay, well, I will deny the request to park commercial vehicles then.
So your
Let me-
motion,
let me start over again then.
go ahead.
Okay. The request is to park commercial vehicles and I will deny that request.
So the motion's to deny the request to park the commercial vehicles, and then on the other,
As far as needing a variance due to the property being subdivided without a plat, I will, move that we approve that request.
okay, have a motion to approve, the request that the lot be declared a legal lot of record, and deny the request for, parking of commercial vehicles. Do I have a second?
I'll second.
Have a motion and a second. Now, discussion on the motion by the board.
Do you think that there needs to be any acknowledgement that the applicant is stating he's going to try to fall under the provisions of a home occupation going forward?
Well, I think that's in the transcript a number of
Okay.
times.
All right.
Any further discussion? If not, all in favor vote aye. Aye. Opposition vote no. The ayes have it. Okay. Thank you. Our next case is case 4168, Civil Site Design Group, on behalf of Nancy Gateline, is requesting a variance from the requirement of 50 dwellings for a cluster development. The variance will allow the cluster development to have 34 dwellings. The property is located at McCreary Road, Lot 2, Gateline property, parcel 105.05 on Wilson County Tax Map 116. The property consists of 41.61 acres and is zoned R1 residential. We get staff recommendations now on 4168.
Mr. Chairman, the applicant is requiring a variance, or is requesting, a variance from the requirement of 50 dwellings in order to be able to accomplish a cluster development. This development has adequate acreage to meet the 50-foot allowance requirement. In fact, when they first submitted it, they had more than 50 lots proposed with their sketch plat, I believe. However, there are wetlands on the property, and I'm going to point those out roughly. You see these lines down here at the bottom? Basically, this field down here going up into across the tree line, I believe is an area that has been determined to be wetland area. So those wetlands are preventing a portion of the property from being desirably developed. The developer wants to develop 34 lots, but he still wants to be able to use the cluster provision so that he can make use of open space criterion to avoid those wetlands. And keep the lots out of the wetland area and still be in keeping with their sketch plat approval. This will allow the property to develop with smaller overall lots than the 40,000 square foot minimum lot size typically allowed in the R1 zone district. The property, by math, would permit, and using the cluster provision estimate, would permit as many as 52 lots as a use by right. But this request has come before you to allow fewer lots and still honor the cluster requirements. Given the language in the zoning ordinance, staff cannot recommend approval because there is a 50-lot criterion. However, staff will note that the layout as proposed does keep lots outside of the wetlands area on the property.
Okay, who should represent 4168 Gateline?
Good morning, Joe Haddock, CSDG. Thank you for the introduction, Tom. As he mentioned, this is kind of a interesting or unique situation. Came through Planning Commission in February of last year, received sketch plat approval for concept plan. As Tom mentioned, contained 53 lots. We had done some preliminary environmental work, so we knew we had some kind of wetland possible, but further south is what the original group was telling us. After discussion, actually with Mr. Evans, we sent the environmental group back out there to double check, and lo and behold, they come back with a 14-acre wetland on the south end of that property, which is about 35% of the site. So we went back to the drawing board to some extent and submitted a preliminary plat that contained 34 lots. In discussion with staff, Tom and Christopher, it was determined to bring to this board because we did not in fact meet the 50 lot requirement for the cluster provision, and it was a difference in what we had originally submitted. So that brings us to this morning. We respectfully request your consideration of our request, and I can answer any other questions y'all may have.
I guess my first question is, I'm not familiar with all this. I don't know we've ever had one exactly like, so what is the lot size in this cluster development?
They average between, just shy of half an acre, like 0.4.
So they go from
just under half acre. They're like about 20,000. I mean, it does
What's the
meet.
smallest lot?
Smallest lot. Bear with me. There's a 16,000 square foot. There's a 15.5, 15.3. So they're very comparable to the Stonefield subdivision directly adjacent.
Or do they get that small over in Stonefield?
I believe some of them do, yes, sir.
how small can they get in under this cluster development?
Under a cluster, they can, there's not a lot, they established the lot size, they can go no more than, number of dwelling units per acre cannot exceed 12 units per acre.
You can have 12 units on an acre.
Can't exceed that. We haven't had many clusters get anywhere near that. Or I don't know of any that we've had get that small. That'd be like a
Have we ever
2,000 or
heard this
3,000
type of request before?
No, I mean, the alternative would be, it's twofold. One, they could try to do a cluster, have smaller lots, get above 50 lots, but they're probably gonna have wetlands on private lots, which is not ideal. The other alternative would be that they increase the lot size to the 40,000 square foot minimum, and it would, likely be 16 or 17 lots tops, at acre lots. But even at that, they would probably have wetlands on private property if they did it that way.
Does the cluster development criteria specifically say they can come here for a variance, or is that just?
It's part of the zoning ordinance.
Well, I mean, it's part of the zoning ordinance that anybody can come here that's agreed by the ordinance.
Right.
But does the cluster provision specifically tell them they can come here for a variance?
Not to my knowledge.
And if they make the requirements of a cluster, obviously it just goes right for the planning, right?
Yes, sir.
So
Yes.
Just to add, if I may,
Right.
we had been to planning prior to the
Right, I
knowledge of
remember
this
you- yeah.
large, and it was approved by planning at that point.
Did you say the houses would be comparable to, Stonefield subdivision?
Lot size, yes.
Lot
and
size
Lot size, and
in
our
Stonefield.
builder, these, so for comparison, y'all probably familiar with Ravens Crest, right? Those lots are probably 60 to 70 foot wide. We have 90 foot wide lots at the road frontage, so a little bit wider. And this is more of a custom builder, not one of the large scale groups you've been seeing within the county. So,
Board have any other questions for the applicant? And if you have any, excuse me, go
Well,
ahead.
no, I mean, I don't know, I wasn't aware that such density was allowed in R1. I would've thought that was like. what-
Under the cluster
Well,
provision.
you take the gross acreage and you take 25% off the top and you calculate in the minimum lot size for whatever zone district you're in. In R1, it's 40,000 square feet. When you do that calculation, that gives them 52 lots. So it under the concept that if they were to build that wall to wall with 40,000 square foot lots, they could get roughly 52 lots.
Right.
But they are permitted by the cluster provision to reduce the lot size, still get 52 lots,
And keep some green space.
and keep some green space, stay out of environmentally sensitive areas like wetlands, et cetera.
So the same overall number of lots as if the site was developed to 100% potential.
That's the concept, yes.
I mean, you say that's the
Yes.
concept, is that the way it really works in the real world?
And for the most part, yes. I mean, I would say on most development, and this is just rule of thumb, most development of residential development, between 15 and 25% of any tract is taken up with roads, infrastructure, and I guess sensitive area avoidance, riparian buffers, wetlands, what have you. This one just happens to have a significant amount of environmentally sensitive area.
Board have any other questions for the applicant?
And that south field does inundate with water as well, so it would be good for them to stay as far away from that as they can.
Who owns that wetland or maintain, or they may not maintain it or don't maintain it or stay out of it?
They
Or
would,
who preserves it as a wetland?
the state of Tennessee, likely number one, but secondly, our stormwater department will have some responsibility to kind of keep tabs on it.
Okay.
Typically, the HOA, the homeowners association, that a cluster does require, whereas a straight zone district doesn't require an HOA, that's another problem. But a cluster does require an HOA. Typically, we will get a development contract that turns over responsibility of open space to the HOA, both in terms of their covenants and restrictions, and also specific contracts with stormwater for stormwater and environmentally sensitive areas to be maintained by the HOA. So that way, our stormwater office has a single point of contact to hit up if there's an issue. They could contact the HOA, say, hey.
But the ordinance under this cluster provision sort of represents that every parcel is subject to 100% development. Where in reality, if you didn't go to the cluster development, that's probably not the case. Parcels are rarely 100% developable.
Right. That's why it has the 25%. You take 25% of the total acreage off the top when you make the
Which would be the
calculation.
case in any development, because you always have to have roads, sidewalks, curbs, infrastructure, whatever.
Yes, sir.
The board have any other questions for the applicant? I'll call for others who wish to speak.
Tom, did I just understand you to say that stormwater passed on this?
Huh?
Stormwater?
Stormwater will review it during the subdivision process. They've had a sketch plat, they're at preliminary plat stage right now. So there will be road and drainage plans that stormwater will review that includes
Exactly.
getting
yes.
this reviewed.
Does anyone else here wish to address this case?
I just want to say
Just come up here and give us your name, please.
sure, my name is Don Graham. I'm the adjacent homeowner to the property. I just want to say I'm in full favor of supporting the development at the location. So,
Thank you, sir. Anyone else? Yes, ma'am. Come forward, please.
I'm Victoria Severe. I'm at 385 Cobblestone Way. So my property is on the corner, it backs up to on the corner, that L-shaped one, up a little higher.
Right here?
the L shape, a little higher in the corner.
Oh,
There,
up
yep,
here, I'm
mhm.
sorry.
Yep, that's our property.
Okay.
I just wanted to go on record to mention that I'm not a fan of the development in general because of right there, Stonecrest Drive. That is currently a dead end, so we are very concerned that there will be a road that will connect and be a throughway between McCrary Road and Cobblestone Way, and that will create a lot of traffic and inundate our neighborhood. I'm also concerned about the flooding, which you all obviously brought up, because that field, even past the wetlands, does flood, and where that water will go, and how that will, the responsibility of the developer to make sure that that flooding or that water doesn't find its way into into Stonefield.
Thank you. Anyone else wish to address? Yes, ma'am.
Hi, I'm Andrea Rowe. I live at 700 Stonecrest Drive. That's the house adjacent to the bottom green ones, second one in.
That one?
Correct. I just want to go on record because of the flood piece. I have pictures on my phone from when it flooded last time, and it goes adjacent to my property. So where you're saying it is actually a lot higher up. So, I mean, it's just concerning. It's a wetland area. There's a ton of wildlife out there. It would be really sad to see that go for another subdivision when our school is already completely full. We can't keep teachers in the school as it is. My son went 2 months without a teacher this year. They couldn't replace him or replace her. No one applied for the job. Now there's 20 kids in his class. There were 16 at the beginning of the year. They've all been offered summer school to make up for it. So now my son doesn't get summer vacation because he has to redo 2 months of school because the school is so completely overpopulated as it is. You could assume that these types of houses would be single-family homes with kids in them. The road, Stewart's Ferry, can't take any more traffic in the morning. It's impossible. It's already got construction vehicles everywhere. It's just, I don't know. 50 is a lot. 34 would be preferable if we have to do this at all. That's all I'd like to say.
Thank you. Anyone else? Okay. We'll close the public comment period and turn it to the board for discussion or a motion.
Tom, I have another question. And I don't know if there's a good answer. So how or why was 50 the determining factor?
It predates me being at Wilson County. My presumption is, and this is just a pure spitball presumption, and it's always been my assumption, is that they put the 50 lots in there because anytime you require an HOA, the HOA is responsible for collecting dues to maintain open space improvements if it's in different infrastructure, like we require some active open space improvements with most any development. And so they have to get liability insurance, and they're also required to maintain those open space areas. When they collect dues, if you don't want the dues to be exorbitant, then you have to split it amongst enough people. And so my supposition has always been that the 50 lot threshold was likely selected as a reasonable number to accommodate those open space improvements and the liability insurance that most HOAs have to obtain in an effort not to have them coming back in here and trying to turn the land over to the county when it was never ours to begin with because they don't want to maintain it anymore.
But this request is not about how many dwellings they have on the property, but this is a request to use the cluster development for the 34 that are proposed, to use the criteria for the 34.
Correct, so that they can go to a smaller lot size. Yes.
So the request is to use the provisions of the cluster development on this particular parcel.
And allow them to set their own lot size.
Let me just, because sometimes when we do things for the first time, if we do, we have unforeseen consequences.
Absolutely.
So a few months ago, the county commission raised the minimum lot size.
Yes, sir. It was 25,000 in R1. It's on public sewer. It's now 40,000.
Right. So as a developer, if we were to do this, why would I not use this case to to lean on in the future to be able to use the cluster criteria on my subdivisions that were less than,
Well, you can still use the cluster. We changed the zone lot size, but you can still use the cluster provision. The only difference is the calculation is different because it's not calculating in 25,000 square foot lots, it's calculating in 40,000
but
square
I would be
foot
pretty
lots.
comfortable to come back here and get a variance from the 50. If I only want to develop 25 on my cluster,
Yes, sir.
or 20, or
Yes,
5,
sir.
or 45, or whatever the number.
The only benefit is you know that they're not maximizing the density. So their impact is less than had they just come in and said, I'm gonna do a straight zone district. I'm gonna designate these as wetlands on private property.
But I bought an old piece of property on the cheap, and I'm just gonna put 18 lots here on the little corner that's.
The math still has to do for,
One thing that's unique about this request is they qualify for the 52 lots. I think, I don't know if it remedies your concern, but you're worried about somebody buying a piece of property and only being able to get 18 lots and they want to utilize the cluster provision.
Exactly.
This property still qualifies for those 52 lots. Like, if you can't get to that, we wouldn't even
We wouldn't be
review
here.
it for a cluster provision to start. You have to at least get to that 50 lot threshold.
But they may come here first, and if we find that 18 lots is okay, then you don't have a choice.
Well, look, yeah. That'd be a
I'm just
really
trying to
bad
think
thing, 'cause
through
it
all
states
of what
it
is,
has to
because
be
somebody will.
50 lots. I think they would have to supply some sort of proof to you stating that they can get the 50 lots under normal circumstances before they can ask for forgiveness.
And the only way,
Regulation.
in R1, on a smaller acreage, that they might be able to do that is to get it rezoned. We had a rezoning recently it was just this past county commission whereby I think it was 12 acres. Somebody got zoned to R3 from R1 to replace what was an older mobile home park off Gill Road with, I can't remember how many tracks, but I think they went from about 8 or 9 mobile homes to 14 single-family lots. And they did that by going to R3 so that they could get a smaller lot size.
All right, we're to the board now for a motion in regard to 4168 Gateline. Do I hear a motion?
I'll make a motion that we deny, based on the staff recommendation, based on the lack of infrastructure in the area, and based on the adjacent homeowners' testimony.
Okay, I have a motion to deny 4168. Do I hear a second? I'll second, just for purposes. Okay. Any further discussion? All right. All in favor of the motion to deny, vote aye.
Aye.
All that are opposed to the motion, vote aye. Or vote
I
nay.
don't know.
Vote no.
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 I'm a no.
You're a no, Perry's a no, motion fails,
Three,
okay?
two, three.
All right, motion to deny fails. Well, the floor is now open for another motion.
Mr. Chairman, I will move that we approve this, based on the testimony given here, based on the fact that this did meet the guidelines. It's already been before planning.
Well, has it been before
It's
planning?
been, sketch plat as,
Of
that
what?
showed, a sketch plat that showed 53 lots as. And then when they got
53
to,
lot version went.
Right,
Yeah.
well, right. And then the hardship being that because of the wetland, they had to downsize from the original sketch plan to where we are today. Does that all make sense?
I think so.
It's not a legitimate hardship because it was there when they bought the lot. All right, motion is to approve 4168, correct?
Yes.
All right, and the reason being,
Based on the testimony given, the fact that they submitted a plan to the planning commission for 53 lots, and then the fact I'm calling it a hardship whether it is or not, the fact that there was a wetland and they had to downsize to the current 34 lots.
okay, and this is for the 34 lot proposal only, correct?
Yes.
Okay, all right,
But it did meet the requirement, maybe to protect us going forward, this did meet the requirements land-wise, acreage-wise, for the 50 dwelling, as Christopher was saying a minute ago. I wanna get that in there.
That's correct. It complied with the cluster criterion.
It met
For
the
in
cluster
concept.
comply.
When they got into doing a little bit more detailed analysis, they found wetlands.
Right.
I still don't see why this doesn't open us up for abuse, but. All right, I have a motion. Do I have a second?
Second.
Have a motion and a second. Now, any discussion? If not, all in favor vote aye.
Aye.
How many ayes we got? 1, 2, 3, 3 ayes. All opposed vote no. I vote no. Howard votes no. So motion passes 3-2. Okay? All right. Anything else, Mr. Bashir?
No, we had some interesting ones today.
Big pardon?
We had some interesting ones today, and I do have one thing. April 8th, I believe is correct. Let me look at my calendar real quick.
Yeah, that's right.
April 8th at 6 p.m. We have Jessica Hill with GNRC coming in to provide a presentation from the GNRC regarding our ongoing land use update process, land use plan update process. It's a joint meeting between the Planning Commission, the County Commission, and any of you that would be interested are welcome to come. And it's more or less an informational session to let her outline what we heard from the public during our public hearings, as well as what we've heard from the stakeholder surveys we've done with the planning commissioners and the county commission. And then outline what the process is going forward for additional public input and so on and so forth, which will likely come when they have a draft.
How do you, and I don't know if this is a fair question, but just as you could gather, I mean, from here today and everywhere else, I mean, public input is they've had enough growth, so how do you?
Yeah, I mean,
in a nutshell, I mean, you know,
I will
where
tell
do you go,
you,
you don't.
my perception from our public hearings that we had, prior to the growth plan, kind of throwing a big monkey wrench in the middle of everything, and that's, thankfully, that got approved by the state yesterday, so it's pretty well done. They've got to get us the official forms we can record, but, so the growth plan adjustments have been done. The planning commission, or the land use plan has started back up in earnest. And I will tell you, it's my perception from the original public hearings, we heard loud and clear from everybody that they're just growth fatigued. Is my way of putting it. To that end, because we had a delay in the land use plan update, we did attempt to at least express that we'd heard that by establishing new lot sizes that were less dense. I guess as a response to what we heard initially from the land use plan hearings. And there will be additional opportunities for public input later on this summer.
Okay.
Summer and fall.
If that's it, we'll go ahead and adjourn, and we are adjourned. Thank everyone for coming.